Okay, we're going to talk about in the interest of justice. It's a legal term. Most people don't realize a lot of the stuff they see and hear with political pundits, legal pundits, lawyers, judges, in politics when they talk about in the public interest. Remember, my last video, I said it's the legal requirements of doing what's in the public interest. It's the law. So a lot of times you see these politicians talking about doing what's in the public interest, but every public servant is legally required to do what's in the public interest. And I did a video and see if you liked it. But the whole point was I was trying to get people to understand a lot of the stuff that I talk about, the terms I use, and I try to encourage you to look up that these are laws we're talking about. Okay. Candor, tort, tribunal, diligence, expediting litigation, competence. Those are laws in a court of law, if you ever read the rules of professional conduct. Okay, let's talk about the interest of justice, okay? In the interest of justice is a legal principle that means an action is taken to ensure fairness, equity, and a just outcome in a case. Its subjective standard allows judge discretion to make a ruling based on the specific facts of a situation. It's often invoked when a case is being moved, transferred, dismissed, or when a judge is considering a particular ruling. Factors considered includes convenience, fairness, the location of evidence, the potential impact on the judicial process. Key applications: case dismissal. Case can be a court case. A court can dismiss a case if it determines that the dismissal is necessary for a fair resolution, even if the case is technically procedurally sound. Change of venue. Judge may move a case to a different location. It would be fair to move or more convenient for all parties involved, for example, due to the location of witnesses or evidence. Judicial discretion. The phrase gives the judges flexibility to exercise their discretion to ensure a just result, when other legal rules may be ambiguous or lead to an unfair outcome. How would it use? Motion. Lawyers may file a motion arguing in the interest of justice to ask a judge to rule in their client's favor, especially in situations where there might be a strong legal precedent to rely on. Subjectivity. The interpretation of what serves in the interest of justice is subject and depends on the specific facts of the case and individuals involved. Okay, so I was the other one I was telling you the requirements of doing what's in the public interest. So you want to add in the interest of justice. I was discussing with a couple of people about a closing statement when they file, whether it's with the Civil Rights Department, DOJ, the FBI, whether they're filing a complaint, against a judge. All you got to do is type in Code of Judicial Conduct Complaint Form or complaint against a lawyer, Rule of Professional Conduct Complaint Form. And when you close it with candor towards a tribunal in the public interest, in the interest of justice. Justice must be served. I trust you will be diligent, expedite that litigation. That would be competent. I hope my communication is correct. But see, communication, that's a law in a court of law. Your lawyer's supposed to communicate with you about everything. They usually keep you in the dark, which is illegal. Expediting litigation. You know what expedite means, right? Do shit quick, fast, and in a hurry. Diligence, meaning, doing shit quick, fast, and in a hurry. So it would be diligent to expedite litigation. That would be competent. failure to do so is misconduct. And in not doing so, it must be reported. Reporting misconduct is mandatory for all lawyers and judges, even if they aren't involved in the case, just the general knowledge. They don't have to be a participant. Just the general knowledge of any misconduct in any case by any other lawyer or judge is grounds for them to report that misconduct. There is no limitations. Zero tolerance. There's supposed to be zero tolerance. Okay, so, I always use the rules of professional conduct. A young lady asked me, because she was filing with the DOJ, and she had to give it 500 words or less. So I put the judge failed to cite my attorney for ineffective assistance of counsel, the opposing party for multiple counts of misconduct, and themselves as well as for multiple counts of misconduct, and the Code of Judicial Conduct, as well as rules of professional conduct to reporting misconduct is mandatory. The judge failed to report the lawyers failed to report the judge, everybody failed to report each other and themselves as well, thus all proven guilty of deprivation of rights, and they all failed, and they're in with everybody. I forgot how exactly, but everybody failed to report misconduct, thus proving a conspiracy against rights under the color of law. So, in public interest, in the interest of justice, and I just add that on to that young man, I forgot his name. Let me go here really quick.
The white elephant. Gift exchange, equal parts holiday cheer and psychological.
See, he said a whole lot in a minute and a half. See, some people will take some of my videos and string a whole bunch of laws together. And that's got it right here.
My attorney for ineffective assistance of counsel. Reporting misconduct is mandatory in both the Code of Judicial Conduct as well as the Rules of Professional Conduct. The state's attorney should as well then, Your Honor. You took an oath of public service, and violation of that oath is treason. Not to cite my attorney and the state's attorney for violating the rules of professional conduct is a violation of that oath. In judicial conduct, you are also legally obligated and required by the Code of Conduct to do so. My attorney and the state's attorney are therefore required to cite you for judicial misconduct upon failure to do so. Informed consent is required before these proceedings can go forward. It is required I have reasonable knowledge to give informed consent, and that reasonable knowledge would be informing me exactly what due process is, and that's explained in the Rules of Professional Conduct and the Code of Judicial Conduct. A fair trial would require everyone in a court of law making sure that I have reasonable knowledge to give informed consent. Now, effective assistance of counsel is a double-edged sword and cuts every way you swing. Every attorney is required to abide by and enforce the rules of conduct as well as judges. Every lawyer and judge are required to abide by and enforce the Code of Judicial as well. Preferential treatment is forbidden in every court of law, and thus far you have given my attorney and the state's attorney preferential treatment, and they you. Let's not forget the requirements of a quick and speedy trial, which has limits. No one has explained any of this to me. With this being recently discovered, I ask that this case be dismissed with prejudice and for all of you to do what's required of law and report each other to the proper authorities. Thank you, Your Honor. My attorney for ineffective assistance of...
Now you gotta admit, that said a whole lot. And if you read the Rules of Professional Conduct and the Code of Judicial Conduct, that's a ton of laws they broke. Somebody was asking me if I could, direct them which laws they could use. In the interest of justice, the latest one was terminology you could use. in the public interest, legal obligations to act in the public interest, about how qualified immunity shouldn't exist. Nobody can use it, especially if they knowingly and willingly violate your constitutional rights. And you have a constitutional right to effective assistance of counsel, and the requirements of effective assistance of counsel are stated in the Rule of Professional Conduct and the Code of Judicial Conduct, which apply to all attorneys and judges in a court of law. Okay? Deprivation of rights. The privation of rights starts with your attorney because they didn't go over what that guy said. Okay. Public trial. Everybody has a right to a public trial. Some people I've been teaching are finding the judges are closing the trial. They don't want no witnesses. It's closed court. And this is in child custody. He is literally divulging a conspiracy against rights under the color of law in child court. And not just against themselves, but others. He's proving conspiracy against rights. Okay. I put word qualified. I have different aspects of this one. I forgot what this one was. I just wanted to talk to you about. Okay, look at it. We hold these truths to be self-evident that all men are created equal and they are endowed by their Creator with certain inalienable rights. Among these are life, liberty, the pursuit of happiness, and that hasn't happened yet. That's the privation of rights. If that had happened, I've talked to many people, and they told me, you don't understand the forefathers, what they meant when they wrote that. I know they didn't mean that, and they didn't do it. And it's still not being done to this day now. And I've been proving to people over and over again with the laws that I give them that they've never had effective assistance of counsel. That they never had a fair trial. They never got a quick and speedy trial. If you read the Rule of Professional Conduct, people say, well, that's only in a criminal trial. No, the Rule of Professional Conduct openly require that every lawyer be diligent in expediting litigation, candid towards tribunal. It's just... It's okay, so he was asking me, which videos should I use? Can you direct me? I would suggest going through all of them. Okay, this is it. Penalties for putting loyalty to a politician versus U.S. Constitution. I mean, anybody, like when you're in court, and everybody's going by the judge's desires, which is quite common, they're putting their loyalty to that judge before you. When the oath they took, even the oath the oath of public service, look that up, they took it's to the Constitution. The Constitution was dedicated to serve and protect we the people from wayward public servants. I did a video on that, so I don't know exactly which ones you're going to want to use. I always tell buddy, use your own magic. There's a lot of different laws I post that you can use, and where and how. Ooh. This is a longer version, I think, of that guy saying what he was saying. Chief Justice Roberts. Okay, says the rule of law is eroding. So I showed you the penalties for violating the rule of law, which are severe. It's just that nobody's being charged. The penalties are fines, removal from public service, and incarceration, and if death is involved, the death penalty. Just saying, I'm going over the laws with you. That's all. I remind a lot of people about this.
Wake up, it's a long night, dark.
All right, violating your oath is a federal crime. Lawyers don't like to hear it. I only told it to 2 judges, told it to a lot of cops. Now it's on the net. Now it's on the net, It's not just in books anymore. And take advantage, of what the time you're saving yourself from what I went through to find this stuff. Keep calling out a judge for conspiracy against rights under the color of law.
I'll talk to you about.
This guy did it. He was really good at it. Big John Cannon. Big John Cannon of the High Chaparral. He's a badass. Everybody's going through that. Privation of rights. And I even explain under the color of law. And that's what you're living with. That's what we're all living with. We're living under the color of law.
You take the blue pill.
I've been at this for a long time. This isn't even the beginning. This isn't even where I started. This isn't even where I started. What's this?
A strong man is not built in peace. He's forged in chaos. He's not the loudest in the room.
Violations of the rule of law.
He's the quiet one. Grinding in silence, carrying battles no one sees. He doesn't run from pain, he walks through it, knowing struggle is part of the process. When life throws storms, he doesn't fold, he adjusts his armor and faces the wind. A strong man doesn't seek attention, applause, or approval. He seeks growth. While others wait to be saved, he saves himself. He leads, he protects, he rises. Discipline is his weapon. Consistency is his shield. His strength is not just measured in muscle, but in mindset, in restraint, in how many times he's been knocked down and still stood back up. He's not perfect, but he's powerful. He's not fearless, but he's relentless. That's what makes him truly strong. A strong man is not built in peace. He's forged in chaos. He's not the loudest in the room, he's the quiet one.
The time has come. The moment of truth is here. The question is, are you ready? Are you prepared? Do you have the strength? Everybody wants to win, but they don't understand what it means to sacrifice to win it all. Everybody wants to be a champion, but are you prepared to work hard enough to become the champion that you believe you can be? Do you think you have the mindset now? Do you understand what it means to get into what they call beast mode? But I'm here to let you know right now, ladies and gentlemen, it ain't about being beast mode. It's about life and death mode. It's about putting the time.
This is my apolitical perspective. This is DOJ to enforce English as
Wake the fuck up!
I'm sorry.
When my back come.
Okay. Remember I told you in the rules and the codes it says it's mandatory to report misconduct. Not reporting that misconduct is misconduct. They took the oath to the Constitution and the Sixth Amendment. You are guaranteed effective assistance to counsel, so your constitutional right is their constitutional duty. They are legally obligated to abide by and enforce the rules and the codes. That is effective assistance to counsel. Lack of is lack of a fair trial, a lack of due process. It's not that hard to understand. Once you start putting stuff together, it's my key goal. Make this happen. Now, I got a question for you. Okay. Quite the poetic version of the rule of law. This is a key principle with our Constitution. Started in the Declaration of Independence, and the history of that started in the Magna Carta, the history of the rule of law. I love history. If this had happened, if it had been enforced, Abraham Lincoln wouldn't have reiterated it in the Gettysburg Address. Martin Luther King would not have spoke, and quite possibly have never had this dream that one day that our nation will live up to its creed. That we hold these truths to be self-evident, that all are created equal, they are endowed by their Creator with certain inalienable rights. Among these are life, liberty, and pursuit of happiness. I'm teaching you how to fight for that life, liberty, and pursuit of happiness, and to remind you what the Declaration of Independence says about usurpations of one's life, liberty, and pursuit of happiness. Thank you and good night. May your Creator always be with you and rain many blessings. People ask me why you say that. It's the law. Just because I'm a different religion doesn't mean I get to disrespect yours. Not legally. I mean, any true patriot would recognize that all are created equal, that are endowed by their Creator. There's been many arguments, but still, the law says what it says. In a nation of laws, there is no king, and if there was, only the rule of law can hold that throne. May your Creator always be with you and rain many blessings. I wish you nothing but a long life and good health.